Hi everyone, I'm Alamin Sazan on behalf of my Group 6 as part of our course presenting on employment law compliance in Canada, which is an essential aspect of managing legal risk in businesses. As future business leaders, it is crucial for us to understand and navigate the complex wave of employment laws that govern the employer employee relationship. By complying with these laws, businesses can protect themselves from legal liabilities, foster a positive work environment, and ensure fair treatment of their employees. Let's explore further why understanding and adhering to Canadian labor laws are of utmost importance. Well, one of the crucial aspects of employment law compliance is understanding the potential risks and consequences of non compliance. Because failing to meet the legal obligations imposed by labor regulations can have severe implications for businesses. It is evident that the risks and consequences of non compliance can be significant and far reaching, making it imperative for businesses to prioritize compliance with employment laws. And did you know that in the past year alone, businesses in Canada faced over 10,000 legal cases related to the labor law violations? So now that we understand the importance of employment law compliance, let's dive deeper into why understanding and adhering to Canadian labor laws is crucial. So compliance with these laws bring several benefits to businesses and employees alike. For businesses, it ensures legal protections, minimizes the risks of costly lawsuits, and also helps to maintain a positive brand image. Compliance also fosters a healthy work environment by promoting fair treatment, equal opportunities, and respect for employees. Now let's take a closer look at the Canadian employment laws that business need to be aware of. So in Canada, employment laws are divided between federal and provincial jurisdictions. At the federal level, we have the Canadian Labour Code, which governs employment matters for federally regulated industries such as transportation and banking, etc. The code covers a wide range of areas, including hours of work, wages, leave entitlements, and occupational health and safety. And on the provincial level, each province has its own employment standards legislation. For example, in Ontario, we have that Employment Standards Act, which outlines the minimum standards for employment in the province. These minimum standards for employment in the province cover important aspects such as minimum wage that we all have 15.5 for the time being, hours of work, vacation entitlements, and termination provisions, etc. So it's crucial for businesses to familiarize themselves with these relevant federal and provincial employment laws. Lastly, let's explore some of the key acts and regulations that govern employment practices in Canada. Well, these legal frameworks play a vital role in ensuring fair treatment, equal opportunities, and a safe working environment for all employees. One significant act is the Canadian Human Rights Act, which prohibits discrimination based on protected characteristics such as race, gender, disability. This act sets the foundation for promoting equality and inclusivity in the workplace. Additionally, we have occupational health and safety legislation, such as the Occupational Health and Safety Act. This legislation aims to protect the health and well being of workers by setting standards and guidelines for workplace safety. So, it is important that for businesses to be aware of this industry specific regulations as well, as certain sectors may have additional requirements to ensure employee safety and well being.
Hello everyone, my name is Ruxat Rahman Mim. Now I would like to discuss the significance of employment standards in Canada. Employment standards serve as the backbone of workers' rights and protections in our country, ensuring fair and safe working conditions while preventing exploitation. Let's explore some key aspects of employment standards. First, we have the minimum wage, which is the lowest hourly rate that employers must legally pay their employees. This rate varies across provinces and territories. Currently, the minimum wage in Ontario is 15.5. Next, we have the working hours, which establish the maximum number of hours employees can work without receiving overtime pay. Typically, the standard working hours in Canada are 8 hours per day or 40 hours per week. Any work performed beyond this limit is considered overtime, and employees are required to compensate their employees at a higher rate than their regular pay, usually at 1.5 times the regular rate. Another crucial aspect is vacation entitlement. Employment standards define the minimum amount of paid vacation leave employees are entitled to. The duration of vacation depends on the length of service, with the standard being 2 weeks of paid vacation per year. However, some provinces and territories mandate longer vacation periods or offer additional benefits for employees with more years of services. Now let's talk about fair hiring and equal employment opportunity. It is crucial that we understand legal requirements and best practices that guide our recruitment process to ensure that every individual has an equal chance to succeed. The Canadian Human Rights Act, also known as CHRA, stands as a cornerstone in this regard. It prohibits discrimination based on various grounds such as race, religion, age, gender, and disability, among others. Similarly, the Employment Equity Act (EEA) mandates federally regulated employers to address imbalances within their workforce by implementing employment equity programs for designated groups. Moreover, each province and territory in Canada has its own human rights codes which further protect individuals from discrimination in employment. To achieve fair hiring, it is crucial to adhere to best practices. Job advertisements should use inclusive language emphasizing the commitment to equal opportunity. Transparent and accessible application processes with clear evaluation criteria and confidentiality are essential. Interviews and selection should be based on objective, job related criteria. Accommodation for candidates with disabilities or protected characteristics must be provided. As we continue to delve into the significance of equal employment opportunity and non discrimination in Canada, let's explore how these principles contribute to fairness, social justice, and the creation of a diverse and inclusive workforce. Equal employment opportunity ensures fairness by providing every individual an equal chance to compete for employment regardless of their background or characteristics. Non discrimination promotes a culture that values individuals based on their unique abilities and potential rather than irrelevant factors. Equal employment opportunity and non discrimination are not only ethical imperatives but also legal requirements in Canada. The Canadian Human Rights Act and the Employment Equity Act establish the foundation for these principles. Additionally, each province and territory has its own human rights legislation, such as Ontario Human Rights Codes, ensuring compliance is crucial to avoid legal liability.
Hello everyone, I'm Kashim and I'll talk about the employment contracts. Employment contracts are legally binding agreements that establish the rights and responsibilities of both employers and employees. Understanding the legal aspects of employment contracts is essential for ensuring compliance with employment law. Compliance with employment law, including offer letters, terms and conditions, probationary periods, and termination clauses, is essential to avoid legal issues and disputes. Firstly, the offer letters. Offer letters are typically the first formal communication between an employer and the prospective employee. They outline the terms and conditions of employment, including job title, compensation, working hours, and other relevant details. Offer letters may also include provision regarding probationary periods and termination clauses. The second one is terms and conditions. Employment contracts must clearly specify the terms and conditions of employment. Key elements include job responsibilities, work location, hours of work, compensation structure like salary, benefits, bonuses, and vacation entitlement. Now, the third one is the probationary period. A probationary period is a specified duration during which an employer assesses an employee's suitability for a position. The length of a probationary period can vary, but it is typically 3 to 6 months. During this period, employers may have greater flexibility in terminating the employment relationship without severance, provided it is not in violation of human rights legislation. The fourth one is termination clauses. Termination clauses outline the conditions under which either party can end the employment relationship. They specify notice periods or severance pay entitlement for both employer and the employees. Canadian employment law requires termination clauses to meet minimum standards set by the employment standards legislation, but they can be more generous. Now I'll talk about the legal considerations. It is crucial to ensure that employment contracts comply with federal, provincial, and territorial employment laws. Employers should be aware of their obligations regarding minimum wage, hours of work, overtime, and vacation entitlement. One should always seek legal advice to ensure contracts are properly drafted, enforceable, and aligned with employment legislation. Now I'll talk about termination and wrongful dismissal. Termination of employees in Canada must adhere to legal requirements such as providing adequate notice and avoiding wrongful dismissal. Improper termination can lead to legal risks such as wrongful dismissal claim and associated liabilities. Employers should seek legal guidance and follow best practices to mitigate this risk. Firstly, legal requirements for termination. Employers must comply with specific legal requirements when terminating an employee, such as providing notice. Now, notice periods. Notice periods define the amount of advance notice an employer must provide to an employee before terminating their employment. They vary depending on factors such as length of service, employment contract, and jurisdiction. In some cases, employer may provide pay in lieu of notice instead of actual working notice. Wrongful dismissal. Wrongful dismissal refers to the termination of an employee in violation of their employment contract or without just cause. Even if an employer provides notice, the termination may still consider wrongful if legal requirements are not met. Employees wrongfully dismissed may seek legal remedies, including reinstatement, compensation for lost wages, or damages. Now I'll talk about the legal risk of improper terminations and how to mitigate this legal risk. Firstly, the legal risk of improper terminations. Improper terminations can lead to legal consequences for employers, including costly litigation, reputational damage, and potential financial liabilities. Courts may award damages to employees if they find that the termination was wrongful or in bad faith. Employers should ensure compliance with termination requirements to minimize legal risk. Now, how can we mitigate legal risk? To mitigate legal risks associated with termination, employers should ensure employment contracts contain clear termination clauses that comply with employment standards legislation. Conduct thorough investigations and document evidence when terminating for cause. Provide appropriate notice or pay in lieu of notice as required by law. Consider seeking legal advice before terminating employees to ensure compliance.
Hello, it's Mahfuza Jahan. I'm here to talk about a crucial aspect of managing legal risks in business, workplace harassment and discrimination, specifically the legal framework surrounding these issues in Canada. Workplace harassment and discrimination not only affects the well-being and productivity of employees, but also exposes businesses to significant legal risk and reputational damage. The foundation of this framework lies in the human rights legislation. It prohibits workplace discrimination based on protected grounds such as race, color, national or ethnic origin, religion, age, gender identity, marital status, disability. Additionally, occupational health and safety legislation emphasize the duty of employers to maintain a safe and healthy work environment. Non-compliance with workplace harassment and discrimination laws can have severe consequences for employers. They may face legal action, financial penalties, reputational damage, and loss of employee morale. Now, let's talk about the obligations employers have in preventing and addressing workplace harassment and discrimination. The first obligation is to develop and implement comprehensive anti-harassment and anti-discrimination policies. These policies should clearly define prohibited behaviors, provide guidance on reporting procedures, and outline the steps for investigating. The next obligation is to conduct regular training sessions on workplace harassment and discrimination. Employers also have a responsibility to establish accessible and confidential complaint procedure. When a complaint is received, employers must conduct impartial and thorough investigation. Investigations should be conducted by trained individuals who maintain confidentiality, gather evidence, interview relevant parties, and reach fair and objective conclusions. Now, I would like to discuss another legal requirement for accommodating employees with disabilities. In Canada, human rights legislation prohibits discrimination based on disability. Employers have a legal obligation to provide reasonable accommodations to employees with disabilities. This requires employers to engage in interactive processes with the employee to identify appropriate accommodations. When considering accommodations, factors considered in determining undue hardship include cost, health and safety risk, the size and resource of the organization, and the impact on other employees. Employers must maintain the confidentiality of an employee's disability-related information. Disclosure of such information should be limited. Accommodation should be regularly reviewed to ensure their effectiveness and address any changes in the employee's needs or job requirements. Let's explore the importance of accessibility and the duty to accommodate in accordance with Canadian human rights legislation. Accessibility is about providing equal opportunities for all individuals regardless of their abilities. It ensures that people with disabilities can fully participate in all aspects of life. Furthermore, embracing accessibility also brings social and economic benefits. By tapping into the talents and contributions of individuals with disabilities, we foster innovation, productivity, and economic growth. Now let's discuss the duty to accommodate, which is a legal obligation stemming from Canadian human rights legislation. Employers and service providers are mandated to remove barriers and provide reasonable accommodations to ensure equal access and participation. By fulfilling this duty, we uphold the principles of fairness, respect, and equal opportunity. Moreover, accommodating employees with disabilities enhances moral, productivity, and employee satisfaction. It fosters a sense of belonging and cultivates a culture of respect and support for all employees.
Hello everyone, so my name is Mohammed Bilal and today I will be discussing the occupational health and safety rules and regulations that employers in Canada need to comply with. So each province and territories in Canada have their own rules and regulations regarding the health and safety. So talking about the first point, it's that basically these law outline the general duties and responsibilities of employers, supervisors, and employees regarding the workplace health and safety rules and regulations. The second point, hazard identification and assessments, means that employers are required to identify and assess the workplace hazards to determine potential risks to employees' health and safety. Basically, this process often involves conducting regular inspections, risk assessments, and investigations to identify the possible hazards at the workplace. The third point is joint health and safety committees. These safety committees are basically organization comes up with these committees by selecting a certain designated health and safety representatives who are among the employees, who are people among the employees. Depending on the number of employees and nature of the workplace, these committees basically promote the cooperation between employers and employees to address the health and safety concerns at the workplace. Fourth point is policies and procedures. So employers are expected to develop and implement the health and safety policies and procedures that are tailored to the specific workplace conditions. Uh, these policies can cover a wide range of topics such as emergency preparedness, like for example, it can be any kind of emergency like earthquakes or fire scenes or any kind of. So we need to prepare employees with these kind of emergencies and tell them that what they need to do in kind of any emergency. And they also need to like train them with all the emergency situations, how to get their personal protective equipment, how to always gear up with the PPE kits and all that. Uh, so the training and education part is already like covered. The second last part is workplace inspections and reporting. So employers must conduct regular inspections of the workplace to identify hazards, monitor compliance, and address any health and safety issues promptly. They are also generally required to keep records of workplace incidents, injuries, and any accident that happened at the workplace. So last point is workers participation. So basically in this point, employers need to take the employees input, that how they can address the workplace hazard issues and how they can lower down the ratio of accidents. So we will move to the next slide. So in this slide, we will discuss the pay equity and wage compliance rules and regulations in Canada. So basically, Canadians rules prohibit any kinds of discrimination on the base of races, religion, color, or gender. Any kind of discrimination is prohibited. Moving towards the next point, reducing gender wage gap. So the Canadian law basically promotes that there should be no wage gap based on the gender of the employee. The third point is basically about the minimum wage. The organization needs to comply with the minimum wage that is set by the particular province or territory. And there is also a overtime pay rule that needs to be followed. And if a person works, for example, more than 40 hours, so he or she needs to be paid like 1.5 times of its hourly wage. Equal pay for equal work basically means that every employee in the organization working at the same designation or giving the same kind of efforts to any job needs to be paid at this equal to any other worker that is doing the same job. So that was my part.
Hi, I want to address the two critical topics that greatly impact the world of work in Canada: employment insurance and employment benefits, as well as the importance of privacy and data protection in the workplace. These areas are essential for both employees and workers, and understanding their significance is crucial in maintaining a fair and secure work environment. Now let's begin with employment insurance. This program provides temporary financial assistance to individuals who have lost their jobs, ensuring they have support during challenging times. To be eligible for these insurance benefits, individuals must have paid premiums, experienced job loss through no fault of their own, actively seek employment, and meet the required number of insurable hours. Contribution to employment insurance are shared between employees and employers based on the employee's insurable earnings. This program offers various statutory benefits such as financial aid for the job loss, sickness, maternity and paternity leave, compassionate care, and caregiving. Moving to the employment benefits, these play a crucial role in attracting and retaining employees. Eligibility for employee benefits varies depending on the employer and benefit plan, often considering factors like full-time or part-time status and service requirements. Both employers and employees may contribute to the employee benefits, with contribution amounts varying. Statutory benefits, which are mandated by employment standards legislation, include entitlements such as statutory holidays, vacation pay, and termination notice or severance pay, which can differ by province. Now let's delve into the importance of privacy and data protection in the workplace. Safeguarding personal information is of utmost importance in the digital age. Respecting employee privacy and protecting their personal data not only upholds their fundamental rights, but also it establishes trust within the organization. When employees feel confident that their personal information is handled responsibly and securely, it enhances their trust in their employer, ultimately boosting moral productivity and loyalty. To ensure the appropriate handling of employee personal information, Canada has privacy laws in place. The Federal Personal Information Protection and Electronic Documents Act and the provincial privacy legislation outline key obligations for organizations. These include obtaining meaningful consent for collecting, using, and disclosing personal information, limiting the purposes for which data is collected, implementing security safeguards to protect against unauthorized access or disclosure, promoting openness and transparency about privacy practices, providing individuals with access to their personal information and the ability to correct it, and fostering accountability with organizations for privacy compliance. Compliance with privacy laws are crucial as organizations failing to meet these requirements may face legal consequences, reputational damage, and a loss of trust. Employers must establish clear privacy policies and procedures, educate employees about privacy practices, and update their privacy management practices to adapt to evolving regulations and technologies. So, in so you can say we can say that employment insurance and benefits provide crucial support and security to Canadian workers.
Hello, I'm Dewan. So right now I will talk about the recording and record keeping and the compliance. So according to the Canadian government, it is mandatory for employees to keep the proper records of their employee. So there are four segments to keep the records. Those are like general records, which includes their name, age, sex, job start date, scene, rate of wage, hour provided each day. The second segment includes earning records, like how much they're earning each day, hourly, or over the year, and if they are eligible for any pay leave or other vacation leave as well. In the third section, they have to record averaging records like posted notice, periods of averaging, start date of averaging, detail of reductions, number of overtime hours which are paid. And the fourth thing is additional requirements. So if the employee has any medical terms or any prescriptions, they have to submit it, and the employer have to keep a proper record of these things, which will help the employer in future to assist the employee or to claim the employees. If any employee claim for their assistance, they can easily find those records and take initial steps. So let's talk about what are the risks associated with record keeping and compliance. There are like lots of risks which are associated regarding this thing. So the first thing is non-compliance with employment laws. As I told you guys that according to Canada government, it is mandatory to keep the records of their employees at least for 36 months. And the second risk is difficulty in demonstrating compliance during audit. While statutory audit, every auditor wants to see the records, employee records, and other things during their audit procedure. If the company fails to show the employee recordings, they might face some difficulties, and uh, the auditor can take any legal disputes. In stability to manage employment relationship, it is important to record the employees uh, each and every records, because without their records, an employer couldn't know about their performance, they couldn't know about their dedication. So it's tough for the employer to make good relationships without any recordings about the employee. Impaired decision making. Without proper employee record, it's very tough to assign work or make any important decisions because for a special work, employer obviously need an skillful employee. So if they have proper recording, they can easily know who is their key employee and who should do this job. Difficulties in defending claims. To defend employees' false accusation, it is mandatory to have employees record. Without proper record, the employer cannot defend the false accusation. So, what are the best practices for employment law compliance? So, the first one is ongoing education. Stay updated on federal, provincial, and territorial legislation by regularly reviewing those government website. And the second thing is comprehensive policies. Provide ongoing training and education to employees about their rights and how to record those things. Then there is prior documents, so we have to learn how to document everything, like when employee are entering at the office, we have to write down the time. It can be manual and it can be also infrastructure IT based. And the fifth thing is open communication. Employers should encourage their employee to communicate openly without any restrictions. So it will enable the employee, it will encourage the employee to share their insights, and it will help the employer as well to know more about the employee, and eventually it can help us to make a good relationship among the employer and the employee, and it can eliminate the business risk regarding those things. Thank you.